It is come into force from 4th August 2022 by CG notification. It is an act to authorize for taking measurements of convicts and other persons for the purpose of identification and investigation in criminal matters and to preserve records and for matters connected therewith and incidental thereto. Be it enacted by Parliament in the 73rd year of the Republic of India as follows. Statement of object and reasons. The Identification of Prisoners Act 1920, this is a revision of that particular act. Identification of Prisoners Act is now 1920 has now changed to Criminal Procedure Identification Act 2022. That is after 102 years. It was enacted, 1920 was enacted to authorize the taking of measurements and photographs of convicts and other persons. The term measurements used in the said act is limited to allow for taking of finger impression and footprint impression of the limited category of convicted and non-convicted persons and photographs on the order of a magistrate. New measurement techniques being used in the new act used in advanced countries are giving credible and reliable results and are recognized world over. This act does not provide the old act does not provide for taking these body measurements as many of the techniques and technologies have not been developed at that point of time. It is therefore essential to make provisions for modern techniques to capture and record appropriate body measurements in place of existing limited measurements. The said act in its present form provides access to limited category of persons whose body measurements can be taken. It is considered necessary to expand the ambit of persons whose measurements can be taken, as this will help the investigating agencies to gather sufficient legally admissible evidence and establish the crime of the accused person. That means they are going to expand the definition of measurements, that is different types of measurements to be taken, and expand the category of persons from whom they are to be taken. Both are going to be expanded. Therefore, there is a need for expanding the scope and ambit of the measurements which can be taken under the provisions of law, as it will help in unique identification of a person involved in any crime and will assist the investigative agencies in solving such criminal cases. The Criminal Procedure Identification Bill 2022, which received an assent of President on 18 April 2022, published in Gazette of India on 18th April 2022 and notified by Central Government on 4th August 2022, it provides for legal sanction for taking appropriate body measurements of persons who are required to give such measurements and will make the investigation of crime more efficient and expeditious and will also help in increasing the conviction rate. The said bill inter alia seeks 1. To define measurements to include finger impression, palm print, footprint impression, photographs, iris and retina scan, physical and biological samples and their analysis, etc. To empower the National Crime Record Bureau of India to collect, store and preserve the record of measurements and for sharing, dissemination, destruction and disposal of records. To empower a magistrate to direct any person to give measurements. To empower police or prison officer to take measurements of any person who resists or refuses to give measurements. Next, the bill seeks to achieve the above objective. One title. This act may be called the Criminal Procedure Identification Act 2022. It shall come into force on the date as the central government may specify. I have already given. The date is 4th August 2022. Central government has notified. And it has come into force. Definition 1. In this act, unless the context otherwise requires, magistrate means in relation to metropolitan area MM, in relation to other areas JM, FC, in relation to ordering someone to give security for his good behavior and maintaining peace, the executive magistrate EM. Measurements includes finger impression, number 1, palm print impression, number 2, footprint impression, number 3, photographs, number 4, iris and retina scan, number 5, physical biological samples, number 6, and their analysis, number 7, Behavioral attributes including signatures, number 8, handwriting or any other examination referred to in section 53 or section 53A of the CRPC 1973. Police officer means the officer in charge of a police station or an officer not below the rank of head constable. Prescribed means prescribed by rules made under this act. Prison officer means an officer of a prison not below the rank of a head warder. Words and expressions used herein not defined but defined in the Indian Penal Code and CRPC shall have the same meaning respectively assigned to them in those codes. Now the new codes have come, they take their place. Now taking of measurement, any person who has been this is section 3, taking of measurement. Any person who has been convicted of an offence punishable under any law for the time being in force, or 3b, ordered to give security for his good behaviour or maintaining peace under section 117 of CRPC for a proceeding under section 107 or section 108 or section 109 or section 110 of the said code, or 3c, arrested in connection with an offence punishable under any law for the time being in force or detained under any preventive detention laws, shall, if so required, allow his measurement to be taken by a police officer or a prison officer in such a manner as may be prescribed by the central government or the state government, provided that any person arrested for an offence committed under any law for the time being in force may not be obliged to allow taking of his biological samples under the provisions of this section. Then there comes an, after the provision, that means you need not give biological sample, that is the provision. Okay, then exception. Except for an offence committed against a woman or a child, or for any offence punishable with imprisonment for a period of not less than 7 years. Now it means that if you have committed a crime against a woman or a child, or your crime has a punishment of more than 7 years, then you have no option but to give your biological samples. But if you have not committed any crime against a woman or a child, and whatever crime you have committed, offence you have committed, the prescribed punishment is less than 7 years, then you have an option not to give your biological samples. Now section 4, collection, storing, preservation of measurements and storing, sharing, dissemination, destruction and disposal of records. 4, clause 1. The National Crime Record Bureau shall, in the interest of prevention, detection, investigation and prosecution of any offence under any law for the time being in force, 4.1a, it says, collect the record of measurements from the state government or union territory administration or any other law enforcement agency. 4.1b, store, preserve and destroy the record of measurements at the national level. 4.1c, process such a record with relevant crime and criminal records. And 4.1d, share and disseminate such records with any law enforcement agency in such manner as may be prescribed. Then 4.2, the record of measurements shall be retained in digital or electronic form for a period of 75 years from the date of collection of such measurement, provided that where any person who has not been previously convicted of an offence punishable under any law with imprisonment for any term has had his measurements taken according to the provisions of this act is released without trial. Number 1, released without trial, or discharged from the charges, or acquitted by the court, that is after trial is acquitted. Discharge is before trial, and released without trial even does not go to the magistrate. After exhausting all legal remedies, all records of measurements so taken shall, unless the court or magistrate for reasons to be recorded in writing otherwise directs, be destroyed from records. Then 4.3, the state government and union territory administration may notify an appropriate agency to collect, preserve and share the measurements in their respective jurisdictions. Section 5, power of magistrate to direct a person to give measurements. When the magistrate is satisfied that for the purpose of any investigation or proceeding under CRPC or any other law for the time being in force, it is expedient to direct any person to give measurements under this act, the magistrate may make an order to that effect, and in that case the person to whom the order relates to shall allow the measurements to be taken in conformity with such directions. Now most probably it links to where the provision of the act is not there that compulsorily he should give measurements, then the magistrate has the option to direct. Expedient to direct any person. So here there is nothing to do with the 7 years or woman and child restrictions. Any person. Even arrest also is not there. Arrested for an offence is also not there under section 5. Section 6, resistance to allow taking of measurements. 1. If any person who is required to allow the measurements to be taken under this act resists or refuses to allow taking of such measurements, it shall be lawful for the police officer or prison officer to take such measurements in such a manner as may be prescribed. That is, he can use a reasonable force. Then 6.2. Resistance to or refusal to allow the taking of measurements under this act shall be deemed to be an offence under section 186 of the IPC. 7. Section bar of suit. No suit or any other proceeding shall lie against any person for anything done or intended to be done in good faith under this act or any rule made thereunder. Next, section 8. Power to make rules. 8.1. Central government or a state government may by notification in the official gazette make rules for carrying out the purpose of this act. 8.2. In particular and without prejudice to the generality of the foregoing provisions, such rules may provide for all or any of the following matters, namely 8.2a. The manner of taking measurements under section 3. Then 8.2b. The manner of collection, storing, preservation of measurements and sharing, dissemination, destruction and disposal of records under 4.1 section. Then 8.2c. The manner of taking of measurements under subsection 6.1. Then 8.2d. Any other matter which is to be prescribed or in respect of which provision is to be made. Then 8.3. Every rule made by central government under this act shall be laid as soon as may be after it is made before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or 2 or more successive sessions. And if before the expiry of the session immediately following the session or the successive sessions aforesaid, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect, as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that rule. Next, 8.4. Every rule made by state government under this act shall be laid as soon as may be after it is made before each house of the state legislature where it consists of 2 houses or where such legislature consists on single house before that house. Section 9. Power to remove difficulties. 9.1. If any difficulty arises in giving effect to the provisions of this act, the central government may, in order to publish in the official gazette, make such provisions not inconsistent with the provisions of this act as appear to it to be necessary for removing this difficulty, provided that no such order shall be made under this section after the expiry of 3 years from the commencement of this act. Every order made under this section shall be laid as soon as may be after it is made before each House of Parliament. Section 10. Repeal and saving. The Identification of Prisoners Act 1920 is hereby repealed. Then 10.2. Notwithstanding such repeal, anything done or any action taken or purported to have done or taken, including any rule, regulation or proceeding taken or any rule made or direction given or any proceeding taken or any penalty or fine imposed under the repealed act shall, in so far as it is not inconsistent with the provisions of this act, be deemed to have been done or taken under the corresponding provisions of this act. 10.3. The mention of particular matters in subsection 2, that is 10.2, shall not be held to prejudice or affect the general application of section 6 of General Clauses Act 1897, General Clauses Act, with regard to the effect of repeal. In exercise of the powers conferred by Section 8 of the CRPC, Criminal Procedure Identification Act 2022, Central Government hereby makes the following rules, namely 1. These rules may be called the Criminal Procedure Identification Rules 2022. This will come into force on the date of their publication in the Official Gazette. This has been published in Official Gazette on 19 September 2022. So it has come into effect with effect from 19 September 2022. These rules, identification rules. Now section 2 definitions 2.1. In these rules, unless the context otherwise requires, 2.1a Act means the Criminal Procedure Identification Act 2022. 2.1b Authorized user means a police officer or a prison officer of the central government or state government or union territory administration authorized by the Bureau to access the database. Then 10.1c Bureau means the National Crime Record Bureau and the units under its control. 10.1d Database means the information containing the record of measurements. 10.1e Device means an equipment or information technology system used for collection or storage or matching of the record of measurements registered under the Bureau. Then 10.1f Measurements include finger impressions, palm print impression, footprint impression, photograph, iris, retina scan, physical, biological sample, their analysis, behavioral attributes including signatures, handwriting or any other examination referred to in section 53 or 53A of CRPC. Next, 2.2 section words and expressions used herein not defined but defined in the Act shall have the same meaning as assigned to them in the Act, that is Criminal Procedure Identification Act 2022. Now section 3 taking of measurements 3.1 The authorized user or any person skilled in taking the measurements or a registered medical practitioner or any other person so authorized in this behalf may take the measurements of a person for the purpose of the Act, provided that the measurements of the person arrested in connection with an offence under Chapter 9A or Chapter 10 of IPC shall be taken with the prior written approval of a police officer not below the rank of Superintendent of Police, provided further that the measurements of a person charged with violation of any prohibitory order issued under Section 144 or 145 or arrested under 151 of the CRPC shall not be taken unless such person is charged or arrested in connection with any other offence punishable under any other law for the time being in force, provided also that the measurements of a person shall not be taken on the initiation of proceedings under Section 107, 108, 109 or 110 of the said code unless such person has been ordered to give security for his good behaviour or maintaining peace under Section 117 of the said code for a proceeding under the said section. Next, 3.2 The Bureau shall issue the standard operating procedure for taking the measurements, which may include the following, namely 10.2a Specifications of the equipment or devices to be used for taking measurements, 10.2b Specifications and the format including digital or physical of the measurements to be taken, 10.2c Method of handling and storage of measurements in the database at the level of state government or union territory administration in a format compatible with the database of the Bureau. Then 10.2d Information technology system to be used for taking of measurements. Then next, provided that the state government or union territory administration using its own information technology system shall provide compatible application programming interface for sharing the measurements or record of measurements with the Bureau. Section 4 Manner of taking measurements of a person who resists or refuses to allow taking of measurement. If any person who is required to allow measurements to be taken under the Act resists or refuses to allow taking of such measurements, the authorized user shall take the measurements in accordance with the provisions of Section 53 and 53A of CRPC. Manner of collection, storing, preservation, processing, sharing, dissemination, destruction and disposal of measurements. The record of measurements shall be stored and preserved in a secure and encrypted format as specified in the standard operating procedure. Section 5.2. In case any measurement is collected, the physical form or a non-standard digital format, it shall be converted into standard digital format and thereafter uploaded in the database as per standard operating procedures, which may include the following, namely 5.2a. Process to be followed by an authorized user for uploading the measurements in the database using registered device. 5.2b. Standard digital format in which each type of measurements shall be covered before uploading into the database. 5.2c. Encryption method to be followed. 5.2d. Manner of registering the device. Next, 5.3. An authorized user for matching the record of measurements of a person shall forward the request to the bureau through the device, and the bureau shall match the record and provide a report to the authorized user through the secure network as soon as possible. Next one, 10.4. Sorry, 5.4. 5.4. The procedure for destruction and disposal of records shall be specified in the standard operating procedures. 5.5.1. Any request for the destruction of record of measurements shall be made to the nodal officer to be nominated by respective state government or a union territory administration or central government, as the case may be, concerned with the criminal case in which the measurements were taken. Next, 5.4.2. The request for the destruction of the record of measurements shall be recommended by the nodal officer to the bureau after verifying that such record of measurements is not taken or not linked to any other criminal case. Next, 5.6. Any act of unauthorized access, distribution or sharing of data collected under the Act shall be punishable as per provisions of Indian Penal Code and Information Technology Act. Next, Section 6. Compliance with the standard operating procedure issued by the Bureau, the state government or union territory administration or the law enforcement agency of the central government shall cause its authorized user to comply with the standard operating procedures. Explanation. For the purpose of this rule, standard operating features means any guideline or standards specifications issued by the Bureau for collection, storage, processing, matching, destruction or disposal of the record of measurements from time to time. The Act is over.